Coming up next on Insights on PBS Hawaii, Hawaiians are still trying to form their own federally recognized government, despite many years and many attempts. Tonight we ask if this goal is within reach, and if not, what stands in the way? Aloha and welcome to Insights on PBS Hawaii. I'm Dan Boylan. Are Native Hawaiians any closer to self-governance? Despite years of effort, Native Hawaiians are the only indigenous people in the United States still waiting for federal recognition. The Akaka bill has been stuck in Congress for years. The Ka'uinoa registry has come and gone, and the Kanai Olovalu project is Kanai Olovalu. There we go. I told you it was going to happen. Project has taken its place. Both initiatives started with the goal of signing up those eligible to create a Hawaiian government. Even with state recognition and funding to establish an official Native Hawaiian role, it hasn't been easy. Hawaiians have been slow to register, for some because they prefer a different path to sovereignty, for others because of uncertainty about what they're signing up for. Still others because they prefer a single Hawaii government for all, regardless of its ethnicity. Now that the Kanai Olovalu, let's get this man on camera here and let him do this for me. There you go, thank you. And Ka'uinoa registrations are merging. Will the list of supporters be enough to achieve federal recognition? If not, what would it take to propel Native Hawaiians towards self-governance? We invite you to join our Insights conversation by calling, emailing, or tweeting your questions and comments. The contact information you now see on your screen will be repeated throughout the program. Insights is also streaming live on your computer and will be posted on our website, pbshawaii.org, after the broadcast. The live stream also is closed captioned, just like our broadcast. Now to our panel. Dexter Kaiama, I'm sorry, Dexter.
That's fine.
Once I get started this way, there's no way out, is a Honolulu Native Hawaiian rights attorney and is among those who support a deoccupation of Hawaii rather than forming a nation within a nation. His legal expertise is in the field of civil litigation, administrative, and insurance law. His pro bono work has been in the field of iwi kupuna, the protection of Mauna Kea, halting expansion of fish farms, and challenging the legal jurisdiction of the state courts on behalf of Native Hawaiians facing foreclosure. Esther Kiaaina is Deputy Director of the Department of Land and Natural Resources. Earlier in her career, she worked for Kamehameha Schools and the Office of Hawaiian Affairs. Esther is staffed for Senator Dan Inouye, Senator Daniel Akaka, and Congressman Ed Case. Last year, she ran for the 2nd Congressional District seat that was ultimately filled by Congresswoman Tulsi Gabbard. Senator Clayton chairs the State Senate Judiciary and Labor Committee. He is also a member of the Senate Tourism and Hawaiian Affairs Committee. A member of the State Senate since 1984 from Windward, Oahu, Clayton previously served a term in the House of Representatives from Molokai, Lanai, and West Maui, right? In 2011, the senator voted in favor of Act 195, the law establishing the Native Hawaiian Roll Commission as a first step to sovereignty. Governor John Waihee, also known as my pronouncer and translator, was the first Native Hawaiian governor, elected to lead the state in 1986 and re-elected in 1990. Highlights from his 2 terms include restoring more than 16,000 acres of public land to the Department of Hawaiian Homelands Trust and creating a committee to help define sovereignty. As a delegate to the 1978 Constitutional Convention, he was instrumental in creating the Office of Hawaiian Affairs. In 1993, he created the Hawaiian Sovereignty Advisory Commission. Today, he chairs the Native Hawaiian Roll Commission. Esther, I'm going to start with you. Where are we? You were up there on Senator Akaka's staff dealing with the Akaka bill. 20 years ago now, we were all marching down through town chanting Onipa'a, and yet it seems that we're nowhere further along the road toward recognition or any form of sovereignty.
Well, I don't know if I would agree with that. I think with a fairly new Hawaii congressional delegation, I think it is prudent for them to reassess the situation. I do know that efforts are underway to determine what form of the Akaka bill should be reintroduced by the delegation and the parameters for such legislation. Simultaneously, I do know that they have been engaging, of course, with the White House, the Departments of Justice, and the Departments of Interior. So I think just because federal recognition is not in the news does not mean that it is not of a high priority for the delegation and for the Obama administration. So I'm hoping during this dialogue that we could engage the public and talk about where we are and where we need to go. So I'm actually fairly optimistic that there is an opportunity for federal recognition to move forward. The key question would be under which scenario? Would it be legislatively or administratively? Because I am a proponent who believes that President Obama has the discretionary authority through an executive order to provide a form of a process, perhaps, if not outright federal recognition to Native Hawaiians, certainly a process for federal recognition.
Given the way Congress has been gridlocked and at odds with the president, doesn't it have to be administrative in this political climate in Washington?
Well, an executive order would be his own, and so he wouldn't have to have the support of Congress. So that's why it would be a more expeditious route. If they go the legislative route with regard to the Akaka bill, there will be challenges, but I don't think they should be shy from it. I have long believed that the debate on federal recognition has been misunderstood. It is not ideological. It is a matter of equity. And people have misunderstood the lack of support because of the archaic system in the U.S. Senate where one senator could put a hold on a bill under the unanimous consent calendar, or they could also filibuster a bill. That's not fair. And the Akaka bill is not special. All bills are going through that scrutiny. So I think people need to remind themselves of where we are and where we can go.
Clayton, has the state legislature, has the state government done enough in sort of the breach of the Akaka bill not moving in your mind toward is Bill 195 enough in your mind?
Well, it's the first step in a long process. I believe that sovereignty is an issue that is more understood today than certainly in the 80s when Governor John was governor and when I was at the time chairman of the Office of Hawaiian Affairs. I mean, the discussion has been ramped up and elevated to the point where I believe there's more consensus. It's still a little bit hard for some people to wrap their arms around the idea of nationhood, but the fear factor has been significantly decreased, at least in my time. You know, when Governor Waihee was in office, he made it possible for the settlement to the Office of Hawaiian Affairs. He made it possible for the settlement to the Department of Hawaiian Homelands. These were for breaches of trust by government, and it may have been something that was not understood at the time, but certainly I believe that the people have now come to grips with equal rights, with justice, and the history of Native Hawaiians through time.
John, I'll go back to 1978 when you were establishing the Office of Hawaiian Affairs. Did you think it was going to take 20 years for us to get essentially maybe where people know more about sovereignty and are less afraid of it, but where we still have none?
No, I don't think we had a timeline. We may not even have had a clear vision, but we knew that what was happening, among those of us that were learning things about our history, was that Hawaii was a nation, and that this nation had been illegally occupied, and that there was a feeling, and I think this was really an important motivator, that it would be better for everybody if Native Hawaiians had an opportunity to control their own destiny, manage their own affairs. And so if you look at that kind of thinking, that's what went into the constitutional provisions. But what we did which was I think the kauna behind, or the reason behind some of the form that was used in creating the Office of Hawaiian Affairs, was the idea was to make Hawaiian resources available to Native Hawaiians, so that the issue of self-governance would not be dependent on the largesse of the state, which is a problem we now have to deal with Hawaiian homes. And so the idea of ceded lands revenues was targeted for Hawaiians to be put into a way that could be used for self-governance. The second and most important aspect of that was to create a forum, to create a body, to create a voter list for Native Hawaiians to be able to start to elect their own leaders and to manage their own affairs, to take plebiscites on what they thought the future was about. It really, if you look at it in that sense, the Office of Hawaiian Affairs in sense, and I'm not degrading the importance of what they do as services, but what the office itself really was in terms of sovereignty was a shell. It was a shell to contain two important ingredients for whatever direction the future would take. And the shell contained the idea of a Native Hawaiian base, which was the voter list and the people that are participating, and a source of independent monies. And that's the way we saw sovereignty. We saw our efforts as giving sovereignty a chance.
Dexter, I don't think that you're a great fan of the Office of Hawaiian Affairs or the Hawaiian Roll Commission.
Well, let me answer the question this way. I think with time and with this, with the additional information, dissemination of information that's being provided to our Hawaiian people and to the community in general, I think actually we move further away from federal recognition and closer to deoccupation. As Governor Waihee said, Hawaii was illegally occupied, and it continues under illegal occupation. Because it continues under illegal occupation, of course, then the state of Hawaii cannot exist. If the state of Hawaii cannot exist, then all of the legislation, including Act 195, including federal legislation, cannot move us towards federal recognition. That is an unlawful process. Now, the occupation is based on the law. And as I've spoken with Governor Waihee before, and we've had these conversations
I can imagine, yeah.
on many occasions. There's actually no dispute concerning the lawful status of Hawaii. The problem is, of course, is disseminating that information, making more people aware of it. And that's what I'm doing both in the courts, not only here, but also in the international courts.
And I think, we've had these conversations, and I tell Dexter all the time, if this was strictly a legal issue, we would have won already. Because I think the facts are the facts, and they, in many respects, indisputable. But I think we also have to look at the political dynamic of what we can do, which is where we may have a different approach. And that is, how do we use the tools that we have, the non-legal tools that we have to move forward toward some kind of recognition of self-governance. And I think we ought to start by the idea of what is recognition? What is it? And unfortunately, we treat it as a kind of a bundle based on what happened to Native Americans on the continent, where the United States has this way of saying, we're not going to recognize your people until you agree that you're going to put up with all these restrictions on your nationhood. And that's not the way that it works for most of the world. And one of the important things is that I think that the genius, if you may, of what Senator He did and the rest of the Hawaiian caucus in forming Act 195 was that they divided the question of recognition into its two parts. The first part being whether or not a nation exists. And the second part would be, what does that nation want in terms of a government-to-government relationship? So the state of Hawaii, by passing Act 195, recognizes the nationhood of the Hawaiian people, the indigenous people of Hawaii. And by the way, that recognition can come from anywhere. You know, one of the strategic genius moves I think that my friend Kiaaina did was when he got the International Court of Justice to accept a petition from him. In the sense, that was recognition that we're a nation. The same way what we want...
Well, John, how is that a recognition that
because you couldn't take a petition from anybody that wasn't an existing nation state. Now, what the United States needs to do is to recognize our nationhood. Kanai Oluvalu is about getting, the first step would be getting everybody up and down the line to accept the existence of a Hawaiian nation. The second step of it was to put together a governing entity who would then negotiate the relationship, or none at all, that they would have with any of these levels of government. Now, one of the things that I think, despite everything, where we have moved ahead as a people, is I think there's pretty much universal acknowledgement, wherever we stand on the political spectrum, that the events of the 1890s were illegal and that in fact a nation exists.
But then you're a lawyer, you're a lawyer, you're a lawyer. You and I are unblessed. But three lawyers. Do you really believe that you can take a legalistic argument about what happened in 1893 and 1900 and then run it up to 2013 with all the evolution that has taken place in these islands since and the political context in which everybody has to operate and deoccupy Hawaii? You think that's possible?
And the answer to that question is yes.
How do you define deoccupy?
Well, first off, we have to decide what the lawful status of Hawaii is. Now, there's no dispute that, in fact, Hawaii was illegally occupied. There is also no dispute that there never was any de facto or de jure government that was allowed to transfer any cession over to the United States. The United States has no lawful claim to these islands. There is no treaty of annexation. That is clear, that's undisputed. It's also undisputed both in U.S. constitutional law and international law that countries can only acquire other territory by way of treaty. Because there was no treaty of annexation, the United States has no claim to these islands. Now, addressing your point about the passage of time, passage of time does not affirm any claim. First off, the United States only lays claims to the territory of Hawaii, but there's no legal basis for their claim. I've heard some people talk about the claim of prescription, and prescription essentially is the passage of time. But there are cases before the international arbitration panels that have decided the case of the matters of prescription. Prescription, in the case that I'm aware of, where prescription was granted to a country laying claim over only a partial portion of territory, not an entire archipelago. One of the things that the case set forth as precedent was the fact that the passage of over 200 years had to occurred in that case before the idea of prescription could be invoked. Now, we're not anywhere near that. Secondly, in that case that was, and I think it was the Palmas case, I'm not exactly sure. The other thing about that is that under prescription, there has to be no challenge to the claim. Now, we know historically, we've had many challenges to United States claims, the Ku'e petition in particular, Queen Lili'uokalani's protest to the United States government. So protest has been well established in Hawaii. There is another case that also says, and it's a case I think the United States was involved in, and forgive me because I can't recall the name of that case now, under the idea of prescription, is that prescription is negated. Any claim for prescription is negated as long as there is protest. It doesn't need to be a continuing protest over a period of time. As long as protest is initiated at least once, that preserves or that negates the claim of prescription. Now, in an analogy, prescription is somewhat similar to adverse possession. Adverse possession doesn't confer any rights or title to you. You still have to get that affirmed.
But I don't want to throw a butt at you, Dexter, but I am. You're in the realm of law now, yes. And you're hurling law at me.
Yes.
Rather, there's another history here. 80% of the population of the islands are not Hawaiians. Some of them are in their 5th, 6th generation, right, living in these islands.
Right.
What claims do they have?
And what I can tell you is under the laws of occupation, which is what we are legally occupied. So it is the law of occupation that prevails here, right. Not United States law, the law of occupation. It requires the occupying country, which is the United States, to administer Hawaiian Kingdom law. Under the process of deoccupation, the country must be placed in the position it was just prior to the occupation. So that would include the population or the percentage of population that existed at the time. So what I would say to
in
these...
1893.
In 1893. So what I would say to those people who have been here for 3 or 4 generations, but who are not nationals of the Hawaiian Kingdom, who are not citizens of the Hawaiian Kingdom, they would have no claim as a citizen of the Hawaiian Kingdom unless they applied for citizenry.
I would advocate that rather than using a legal basis for the pursuit of justice, that we take the other route, which would be based on policy reasons. And the reason for that is I believe it's a very complicated question with regard to claims arising out of the overthrow. I acknowledge its illegality, but the remedy must be done within the confines of modern domestic and international law. And as far as I'm concerned, unless the Admissions Act and the Annexation Act has been repealed or ruled invalid in a U.S. court of law, it's hard for me to be in pursuit of an alternative form other than federal recognition. So I'm a believer that we have to acknowledge what has happened, but move forward in a matter that protects federal and state programs for Native Hawaiians, that creates a governing entity where we can negotiate with the state and federal governments, and lastly, do everything possible to preserve our land and natural resources. At the core, whether you agree with independence or federal recognition, we are talking about the same corpus of land, and as such, the first priority, even prior to federal recognition, or in Mr. Kaiama's case, international recognition, we should be pursuing that. We need not wait for federal recognition to be preserving our lands. And I feel blessed to have been able to work on a multitude of legislation, both at the state and federal level, that would have done that. So as you know, I guess I'm just saying in answer to your question, I think the legal basis is hard. And because Hawaiian rights is off the charts in the legal world, our better argument is to argue on a matter of equity, an argument of good policy for the country, and a moral basis that what occurred was wrong, but we can't turn back the clock and unwind all of the subsequent acts that brought Hawaii into this statehood, that annexed Hawaii and all of the lands. I think we need to deal with it, and deal with it in a manner that's prudent for all of the people of Hawaii.
Clayton, where are you on this?
I been at this a long time, like most people here, but I simply I acknowledge the wrongs that have been committed, that Congress has acknowledged, and President Clinton signed it in the apology resolution. So there's no dispute there. I'm a firm believer that it will take a political will to find a solution. Lawyers can lawyer and argue, make the arguments. I don't think necessarily that is the ingredient that will solve problems, because regardless of the issue, you hit the nail on the head when you indicated that there are more people living in Hawaii who are not born in Hawaii. Forget that they're not Hawaiian. But the flip side to that argument is also that many Hawaiians are the products of many different nationalities as well. So I think that kind of statement tends to divide this discussion, and I don't think it serves a real good purpose, because that's an easy out to stop the effort, which is really not, in my mind, a Hawaiian effort per se, but an effort to find justice and equal rights for those who have the koko of Native Hawaiians.
Brett and Ka'ava asked this question, speaking to something you brought up. What's the difference between ethnic and Native Hawaiian? 1% versus 100%?
Well,
what are the definitions here in our discussion?
That's the same argument my mother used to say when she was alive, which is, my father's Chinese. And she used to always say to me, you make a Hawaiian nation where non-Hawaiians are not involved, count me out, because your father cannot join. So, you know, those are the divisive arguments. You see, it's an interesting question, because for my father, he never had a hang-up about not being Hawaiian. In fact, he always made a point, if somebody raised the issue, he'd say, I'm not Hawaiian, my wife's Hawaiian. My kids are Hawaiian, but I'm not Hawaiian. But he never took it like he was less than his wife or his kids. It was just something that he just wasn't part of. But it wasn't an issue. So, you know, I think my mother's view was a Hawaiian is a Hawaiian is a Hawaiian, regardless of quantum.
Well, let me remind you, I think fortunately for us, our Hawaiian kingdom and the Hawaiian kingdom government that existed was a kingdom that was all inclusive. In the 1890 census, if I'm correct, we had over 4,000 people who were of Portuguese ancestries who were Hawaiian nationals. We had over 1,700 Chinese and Japanese citizens who are those ancestries, not Hawaiian, who are Hawaiian nationals. We had over about another 1,700 non-foreign white people, foreigners, who were also nationals of the Hawaiian kingdom. So believe me, the path to deoccupation is not the path of least resistance. Let's face it. It's the path that has been garnering the most resistance, but it is also the one that I think best provides for inclusiveness for all citizens. See, and of course, besides the fact that there is no lawful basis for federal recognition, and if I may, I would respectfully disagree with Esther's statement about a ruling by the United States Supreme Court concerning the annexation or any of the other laws passed, because that's assuming the United States has a lawful claim. And again, history and law will tell you that they do not have a lawful claim. And that's the process that I've been pursuing through the international courts. Complaints have been filed concerning the unlawfulness of the United States and some of its officials here. Recently, I have the International Criminal Court did acknowledge my complaints by a letter to me dated March 4th of this year. And they did assign a docket number to my complaints, raising the very issue of the unlawful claim of the United States and the lawful status of the Hawaiian Kingdom. All I can tell you is that it did get assigned a docket number. It was acknowledged and received, and I expect that at some point I'm going to have a decision from the ICC concerning those claims.
John, I could tell by the way you were clearing your throat that you've got something you want to say.
No, not. You know, first of all, I've heard a lot of this before, and I probably have. I take a little bit different perspective in the sense that I am a lawyer with a political perspective, and you know, I think first of all we need to understand that the quest for Hawaiian sovereignty, at least for me, it is about justice, and it is about our history and so forth. But I don't think you can say that the fact that the kingdom was overthrown 125 years ago is really that long a passage of time for most Hawaiians. There is a kind of a compulsion behind all of this, and with the recognition that my grandfather signed the Kue petition, that my grandfather was crying when they lowered the Hawaiian flag. That intensity runs through our community. For me, the idea of Hawaiian self-governance is more than just theory. I support it because I think it will make life better for Native Hawaiians and for everybody. I mean, why should our people be living on the beach when their native lands are across the street? Mm-hmm. Yeah. I mean, why should 2,700 people be suing in court forever when surely we could do a better job, Native Hawaiians could do a better job running their own programs? It is that kind of motivation. Right? So the first step is, I want people to recognize that my grandfather's nation still exists today, and I want that recognition. Why is that important? Because I don't like the idea that somebody can come across a Native Hawaiian program to help Native Hawaiians in their own land and call it a racial preference. So I want that kind of acknowledgement coming from the state government, which Act 195 did. I want that kind of acknowledgement coming from the United States. The fact that they're illegally occupying us doesn't mean that I shouldn't take advantage of whatever tools I have to make sure that our life gets better. And one of those tools is the fact that we need to be treated as a nationality, whether in occupation or in any other form, as opposed to a racial preference. So what does it take to get that done? And the first thing we need to get that done, I think, is leverage. And we get leverage by unity. You see, I'm real comfortable with talking to Dexter because I hope he wins. I hope he wins. Meanwhile, I hope Esther wins. And whoever wins, I want to be there so I can use that tool to move forward.
This is a question from Foster on Maui. He says, can the panel members define the legal definition of sovereignty in relation to the efforts, and this time I'm going to get it right, Kana'i Olovalo.
Right.
Kana'i Olovalo. Gathering signatures is not sovereignty, and it's misleading.
Well, I guess that's my question.
Well, anybody else can have a shot at it.
You know, since I should at least explain, as the chairperson of the commission, I think Kana'i Olovalo, first of all, the name, so that we know why we have such a pretty name, is the idea of people rushing together. It's the sound of the ocean as the waves rush across the stones. And the idea of Kana'i Olovalo was to put together really a base so that we could have convene a self-governing entity. Act 195 did really, first thing it did was recognize Native Hawaiians. Second thing it did is, in reality, and I tell people this, and this is going to sound really revolutionary, it is trying to do what was done in 1978 with the OHA voter list, which the United States Supreme Court refused to accept. We had some war stories. Clayton and I are walking by Kamehameha's statue in 1993. And I said to Clayton, we got to move this whole sovereignty thing one step forward. We need a Hawaiian constitution. We need a Hawaiian government, right? And that's the beginning of the convention. The convention meets, Hawaiian convention meets, put together a constitution, puts together a plebiscite, asking the people what they prefer. By the time this can get done, the ratification base gets removed.
Act 195 was really the state's effort to say, well, if the federal government won't recognize Native Hawaiians, the state government will do so. And that was the basis of Act 195. And the legislature passed it, regardless of some opposition by legislators, certain legislators, and some community members.
And we're hoping everybody, from every perspective, gets together. Because what Act 95 doesn't do is it doesn't define what the relationships for the future ought to be. See, I believe in unity, and I think unity consists of two things for Native Hawaiian sovereignty. Number one, a belief that we exist as a nation. Number two, that we someday start to appreciate everybody else's efforts. So that if somebody wants to climb this mountain called self-governance from going up this hill instead of this hill, go ahead. You get there first, fantastic.
Leila in IAEA says, in September 2014, Scotland will vote on sovereignty in regard to Great Britain. There is hope for the Hawaiians. There you go, Dexter. OHA's Kauinoa supposedly signed up 100,000 people. Does the fact that the Roll Commission could only secure, what, 14,000 was it?
Yeah, about 15 that are verified.
15,000 signatures after spending $2 million and having the direct support of the Office of Hawaiian Affairs. Doesn't that indicate that people are tired of these kinds of schemes to supposedly create a semi-autonomous governmental entity so they are no longer interested in signing up to support the option?
No.
No.
You want to answer? No.
Sorry, Lanny. No, go ahead.
No, I think first of all, there is a kind of I mean, Hawaiian people are getting tired of all the efforts that have been done, and I don't blame them. And when I talk to them, I say, you know, somebody just the other day said to me, my father was on the waiting list 30 years, and he died. And I said, what do? Give up? For me, I keep trying. So you need to realize that the time that Kana'i Oluwalu signed up 15,000 verified people was much shorter than any other effort given the same time. However, it's also important to realize that Kauinoa and Kana'i Oluwalu is a continuing effort. Kauinoa people signed up knowing that there would be a second step, and that's Kana'i Oluwalu.
Well, I think the question is a unfair question from this perspective. If you look at the Department of Hawaiian Homelands during its early statehood years, really up through Governor Waihee's time, there were very few people who were applying because of a disbelief that they would, in fact, end up on a homestead. Once the Waihee administration enacted a settlement that allowed Department of Hawaiian Homelands, particularly in the Cayetano administration, to begin to build houses because there was a settlement of money, $30 million for 20 years. And people saw the proliferation begin, then the list started ratcheting up. So it's really, in some ways, like the Field of Dreams. Yeah. If you build it, they will come. And so there's some pullback and pushback now. But once it gets started, they will come. And so the question is, it's an easy question to put people down, in my opinion.
And I'm sorry, I would have to disagree with Senator He because I think it's an entirely fair question. As I said in my earliest statement when I began, I says, as more information becomes available to the people, as they become more aware. In fact, many people today are not aware of the fact that there is no treaty of annexation. Most people, because of propaganda, have always believed that the United States annexed Hawaii by way of treaty of annexation. When they become aware that there wasn't a treaty of annexation, people's minds change. And the reason why I say it's a fair question is that as information becomes available to our community, not only the Hawaiian community, but our community at large, I think more people start to question the authority, the very validity of state enactments. And I think, and I would have to say, John and I'm going to continue to massage Governor Waihee because, of course, he's a great spokesperson, a great representative. So, I'm always trying to massage him to start to talk about the occupation because I think that's where I need to lead him. But I think
will not be led. I'll more than you.
What I'm saying is that I think as the information becomes available, I think it will continue to challenge the fact that Kana'i Oluwalu and Kauinoa will have difficult times increasing their registration base.
Esther, when the Native Hawaiian Roll is established, what's the next step from there?
Okay, well, first of all, I think we're losing some...
how does it jive, really,
well, we're losing some discussion, I believe, on the overall issue of federal recognition, which could be assisted by the establishment of the Native Hawaiian Roll Commission, and it could also be done without it. So I think there's been too much discussion tonight on this idea that you need to have the Native Hawaiian Roll done for federal recognition to move forward. So I just want to make that clear. So with or without that, the federal government has the authority to establish a process. The only difference would be that pre-Native Hawaiian Roll Commission, the Akaka Bill was establishing a process which would eventually authorize Native Hawaiians to get together. What this would do is short-circuit the process and perhaps assist any bill that moves forward by having Congress recognize the governing entity established out of the Native Hawaiian Roll Commission. So you have a Native Hawaiian Roll Commission, which will in turn hold a convention. And I guess I'm coming from federal recognition. The convention could certainly talk about other models of self-determination. I'm talking in the context of if federal recognition prevailed, then Congress could more expeditiously pass something that might be of more acceptance to people, because a lot of concern about the Akaka bill had to do with this uncertainty about organizing a Native Hawaiian governing entity. So what it does is it cuts to the chase. I also want to say something about why people are not signing up. I actually think that they are getting tired, but if there are efforts at the state, at the federal level, which moves the process forward, I can assure you that more people will sign up. So I think they're tired. I think Senator He's comments about how you need to feel connected to an issue is very important. They felt connected to the Hawaiian Homelands Program. Now we need to move the map and have them be thinking about self-determination.
Well, I do want to clear up one thing, though. Given any timeline, 15,000 people we actually only have been in operation like little over 7 months, 8 months, in reality. I mean, no offense meant to the good senator, but working with the state process to get things started is not the easiest.
He used to be the state.
Yeah,
Remember
well,
that?
but
Listen
you know,
to that.
hey, but
You see that
you know,
cheap shot?
He's now the nation.
I'm now the nation. You're right. But I got to tell you something though. When I was part of the state, I worked under the delusion that if somebody told me that next week they would have it done, somehow it always met the deadline. Then I became a civilian. And then I realized that doesn't happen for everybody. But anyway, if you look at the time period, we are actually signing up people at a faster clip than any other earlier effort, including Kainoa. So, and it's really interesting. Part of this, there is a kind of a desire, and I think we need to, there is a desire for unity in the Hawaiian community. I mean, there is, it's really, we are trying in a sense to provide or fill that void. You know, we really need to be clear on what Kanai'olewalo is about. I mean, first, it is about state recognition, and it is about trying to get recognition anywhere we can for the governing entity. What it is not about is making decisions about what self-governance should look for. That is what the people should be doing. That is what the sign-up people should be doing.
I can feel it.
Yeah.
You can feel it.
Thank you very much.
Ready to go.
And I don't mean to disparage anyone, but there's some very real concerns about both the federal process with the administrative recognition as opposed to the legislative recognition, and the lack of democracy. Again, notwithstanding the fact that I've continually maintained, and I will continue to maintain, that this is an unlawful process, but notwithstanding that fact, there is something that is inherently wrong with seeking to avoid a democratic process and seeking to gain recognition by mere executive order. There's something entirely devoid of the democratic process. The other thing I need to mention is the fact that what we forget and what we leave out, and I don't know who's to blame or if anyone is to blame, is that sources, by my sources, they've spent between $30 and $50 million in the Kainoa program. And to gain, I don't know how many signatures, how many certified signatures. I think that's in dispute. I think the number of 100,000 people is in dispute when you actually get certification of those people. Secondly, they've also spent, and I can be corrected, anywhere between $2 and $4 million on the registration for Kanai'olewalo, and to gain 14,000, 15,000. Now with the new enactment, which allows Kanai'olewalo to use registrations under Kainoa or other OHA registries, to include them on the roll, I've got to say I'm concerned, or any citizen should be concerned, that they've been deprived their opportunity to give consent to that. And I'm worried that that's what it does. It's like when you register and get your license, you've already agreed that the government can conduct wiretapping on your phone just by the mere registration.
Esther, you got a response to that?
Well, if I may. Well, first of all, my understanding is that there was like, Kainoa spent about $10 million over 10 years. And actually, we've had budgets that equal a little over $2 million. We haven't spent it. And mainly because working, again, with the state is a very slow process, although they're trying very hard. But there is this other question, and the other question is the transfer of Kauinoa names to Kanai'oluwalu. Everyone has an opportunity to opt out. So it's not going to be in a situation where you're forced to take place in it. But the people who signed up for Kauinoa signed up with the understanding that there will be another step that would eventually lead to a convention. So the other side of the coin is not including them in, which is the question that we really get whenever we're out in the field. How come I signed up and now I got to do it again? I thought it was, you guys were all, this was going to be a seamless process. And that's the reason for the transfer.
I actually have concerns about the automatic inclusion of Kauinoa names into this, the new process. And at a minimum, whether it be Kauinoa, the DHHL list, Kamehameha Schools has a long list, what people should be, what I believe OHA should do, or the Native Hawaiian Roll Commission, is seek permission, notify all of them and ask them whether they want to be included. I actually, to protect my own privacy, do not like options that say if you want to opt out. I mean, that's what a lot of the banks do to us, and I don't appreciate it. And so I actually think that there needs to be a balance struck here because of all the funds spent and Hawaiians becoming disillusioned about the process. We need to come together collectively and figure out how to make it work. So what would it take for letters to go out to everybody, asking them whether or not they want to join?
Yeah, well, first of all, thank you, Esther, for making this 2 against 2. Or maybe, you know.
On some issues,
yeah,
yes,
some issues we can move into this.
Yeah, let me get, Melissa wants to know, can a Hawaiian who lives outside the state of Hawaii, is this in 195, besides signing their name on the commission rolls, can they be also a part of the new nation if they do that and participate in making the nation be eligible for the benefits, et cetera, that will be available to those who live in the state of Hawaii? Or are we going to be excluded? I guess she is somebody.
The answer is yes, and exclusion, the answer to the exclusion is no.
They can't.
It's inclusive, yes.
It's inclusive of people who
The
live.
Kanai'oluwalu effort is to establish your Hawaiian, your Native Hawaiian lineage.
And you want to participate in the self-governance.
And you want to, and
When
that
you
would,
form,
but then, doesn't it become, isn't it unwieldy to try to get all those folks
well, I think
on the mainland? In?
Because somebody is in part of the nation doesn't necessarily mean the structure of the government has to be that the structure of the government does not reflect the fact that when you're dealing with Native Hawaiian issues, Hawaii is the center of the area. I mean, people from Molokai don't like people from Oahu telling them what to do. And the same thing. I mean, you're not going to have mainland people dictating issues in Hawaii. But the real question is, do we all belong to the same lahui? What is our genealogy? You know, and that's the beginning.
It raises an interesting question, though. And of course, I have relatives that don't live here, that live on the continent. But it raises an interesting question because the relatives or Kanaka that have moved away have established citizenship in other states or in other countries. Right. So the interesting question that it raises is Kanai'oluwalu or Kauinoa authorized under law to use funding from the state of Hawaii to go outside the state to acquire signatures from individuals who are no longer citizens of the state of Hawaii? And it just raises an interesting question, and I have to raise the question myself. And from a legal standpoint, I think that might invite challenges. The fact that they've expended money, and there's no dispute about it, they've expended money to go out and obtain signatures or consent from non-state residents.
I think for me, the issue starts with what do you consider the ceded lands funds to be? You know, if you consider that to be government money, then this is not necessarily the legal. I think we need to establish the policy before we make the legal arguments, because Dexter knows two lawyers in the same room can come up with 2 sets of different legal arguments. But the policy,
only two? Only
well,
two?
if there was 4, but the policy is whose money is the ceded lands revenues, And as a matter of policy, I've always taken the position that at least a pro rata share of that belongs to the Native Hawaiian people. And I think that that is established even under the United States and the state constitution. So is that money only for residents of Hawaii, or is it for the Lahui?
And Mr. Boylan, I might just add, the only thing that worries me about Kanai'olowalu is in fact that if you don't register with Kanai'olowalu, you are actually excluded from participating in their governance. Again, notwithstanding my argument that there's not a lawful claim. So the comparison between the Hawaiian Kingdom, which is inclusive of including non-Native Hawaiians, as opposed to Kanai'olowalu, which excludes those who do not register, and also excludes those who only is limited to Hawaiian citizens. So I'm concerned about that as well.
That's a good point. We should discuss that.
Dexter, someone, Lanny from San Antonio, Texas. I didn't know we went out that far. To the panelists who proposed a nation within a nation rather than the Hawaiian Kingdom, what is proposed to compensate the subjects of the kingdom who are not of Hawaiian ancestry? That's not you.
Well, that's a question that will be brought before the nation within a nation and dealt with by its delegates.
And they would decide.
Sure.
Can I read that question?
Yeah. You see if you can make out that question.
I think I understand.
There are moments
the
here
question.
when I can't make out the questions. There's no question about that. Now I've got two lawyers looking
You
at
can
the
ask.
question. May come up with
You can ask another question while they're looking
Oh,
at
that's
this.
actually for, that was targeted, I'm the nation within a nation
Yes.
advocate here.
Okay, come on, let's have it, Esther. What's your answer?
It's up for the nation. It's up to the nation to decide.
Yes, but they're specifically, well, first of all, I don't see a lot of non-Hawaiians who are descendants of people from the kingdom coming forward to pursue justice. If they are, then we will deal with them accordingly. And I think that both the kingdom model as well as the nation within a nation model would allow for us to determine who are members. And they and all others who have arrived post-kingdom could potentially be eligible. So I guess my short answer first is I think the issue at hand is justice for Native Hawaiians. And second, with regard to inclusiveness of all other ethnicities, whether it be for the reaffirmation of a kingdom model or with a nation within a nation, the governments would have the flexibility to allow for non-Hawaiians, both models.
I'm gonna say something really radical. Okay, which is
what I said.
I said when you talk about the nation state, which Dexter was talking about, I think that is an inclusive model, and that is traces itself to everybody else. But within that model, even within the nation state, from the formation of the Hawaiian Kingdom, there was a constant, not tension, but a constant, tension would be a good word. There was a constant tension between those that were native and those that came over time. I mean, 1887 and 93, since we talk history, was about foreigners taking over native rights. All right? So even within the kingdom, you had this sort of nation within a nation. That is what so the struggle, the Kue petition itself was basically Hawaiian resistance to the occupation. If you look at nation within a nation in the United States, in a way, and I don't know whether I'm agreeing with you or contradicting you, but if you look at it in that sense, it is about native rights. It is not necessarily about nation-state rights. And I think that's where the difference may be. So, what does that mean to answer that question? It means that, there is a claim, and there might be even a place for those that were citizens of the nation-state. But when we're talking about Kanai'olowalu, when we're talking about things like this, we are really talking about the native people of Hawaii reasserting their Aboriginal claims.
Because they were harmed. Who was harmed?
Actually,
you have to ask the question, who was harmed?
Actually, to answer Lanny's question, though, the non-native subjects, their claims would actually not necessarily be determined by the nation within a nation, the Kanai'olowalu, because that's, again, in the context of federal recognition. The ultimate decision would be made by the federal government, by the state government, in consultation or some agreement with, so that the compensation of those claims is not made.
No, it's not part of the indigenous claim.
Dennis via email wants to know, and Dexter, I'll ask you, isn't this a bill, or I suppose this is your position, isn't this bill just another ploy to subjugate Hawaiians under the U.S. government as an Indian tribe and preclude a true sovereign Hawaiian kingdom?
Well, you have to, when you read the latest version of the Akaka bill, and I know Governor Waihee is opposed to it, but the latest version of the Akaka bill does call Native Hawaiians Indians under federal recognition. So it characterizes us as Indians. So very much so, it does seek to subjugate us under federal law, closely assimilated to an Indian tribe.
Do you see it that way?
Act 195 took the position that federal recognition, if it were to ever occur, would not probably be decades away, and therefore Act 195 sought to establish state recognition. You know, Senator Inouye said, you don't need the federal government to be recognized as a nation.
Clayton,
Act 195 does.
we got to go. I'm always for giving you the
Also,
last
the
word,
Indians
and
don't
also
like
for
being
a
called
chance,
Indians.
and also for a chance to cut former governor off. Thank you all for coming. How can we avoid racial bias against a new or perceived enemy? In the land of the free and the home of the brave, racial bias has played a dark role in our history. At the onset of World War II, tens of thousands of Japanese Americans, including many from Hawaii, were sent to relocation camps by a shocked and frightened United States. Our guests will include a University of Hawaii American Studies professor who was born in an internment camp during World War II, and the president of the Japanese Cultural Center of Hawaii. That's next time on Insights on PBS Hawaii. I'm Dan Boylan. A hui hou.